We will not get outspent by an insurance company.
Today, we are proud to feature McLeish Orlando LLP, recognized as one of the Canadian lawyers' top personal injury boutiques for 2026. Since the firm's inception more than 2 decades ago, McLeish Orlando has focused exclusively on serious injury litigation, dedicating the personnel, experience, and financial resources needed to handle some of the most complex cases in personal injury law. Joining us today is Dale Orlando, principal partner from McLeish Orlando LLP, to discuss the firm's journey, philosophy, and what this recognition means to the team. First of all, congratulations on being named one of Canadian lawyers' top personal injury boutiques for 2026. Thank you.
Yeah, well, thanks, Brody, and thanks for having me on today.
McLeish Orlando has repeatedly been recognized among Canada's top personal injury boutiques, with peers praising your trial strength and client-first philosophy. How do you define what it truly means today to be a top boutique in this field beyond rankings and awards?
I think there's a lot of different aspects of what makes a firm stand out amongst the crowded personal injury field. I mean, obviously having a proven record of success in handling complex, serious personal injury cases is one thing. We've from the beginning, when we started the firm in 1999, wanted to take a leadership position within the bar. That meant, taking leadership roles within organizations like the Canadian Bar Association or the Advocate Society, or primarily the Ontario Trial Lawyers Association, where, I'm a past president, John McLeish is a past president, Patrick Brown has been a past president. So, OLA has been very foundational in terms of elevating the personal injury bar over the last 35 years. OLA just had its 35th anniversary, and our firm and the lawyers within the firm have been actively involved for the majority of that period of time. We're also authors. We write legal texts, and we've been involved in all kinds of lecturing throughout the province. So, those are certainly some of the aspects of it. And last thing I would touch on is being trial ready, Brody. And as big as the insurance bar and the insurance industry is in Ontario, the reputations of the firms are something that are generally known across the board when you're dealing with particular, obviously serious personal injury cases. So having a firm that has a reputation of being able and willing and sometimes relishing the idea of going to trial, it's getting increasingly difficult to get cases to trial. But having that reputation of being, you're ready to go if when called upon, I think definitely helps get cases resolved, and it also helps raise the reputation of the firm within the bar.
Certainly. Your firm has deliberately limited its practice to the most serious and life-altering injuries, and it invests really heavily in each file, emphasizing quality over quantity, which is really what you've been saying. And in an environment of court backlogs and shrinking legal pathways in some provinces, mounting financial pressures on firms, how do you sustain that model while still ensuring timely access to justice for such catastrophically injured clients?
No, you're quite right, Brody. Litigating catastrophic personal injury cases is very expensive. The amount of experts charge have gone up significantly over the years. Firms like ours, we fund our disbursements. We self-fund, so we don't have a line of credit. We don't borrow the money. We fund it out of cash flow. By keeping the number of cases that we take on to a tightly defined group of really serious injury cases, being very selective allows us to dedicate the resources that we need to each case that we take on, whether it's disbursements. We will not get outspent by an insurance company. We're not going to be, we have to take a settlement because we can't afford to litigate. We might have $100,000 in disbursements before the trial starts, so that could easily double by the end of a trial. We've been in the unfortunate position where a case doesn't go your way for whatever reason, and you have to write those disbursements off. So, having that ability to keep the practice small, handling only the most serious of injury cases, allows us to spend the money that we need to spend on each and every case. Also allows us to dedicate the resources. We have a team approach. So every case that we take on has a senior lawyer, a less senior lawyer or junior lawyer on the file, a litigation clerk, um, a legal assistant, but also an accident benefit coordinator. Because on these catastrophic injury cases, there's $1 million available to people for medical, rehab, and attendant care. That takes a lot of management. And our objective in each case is to try to take as much of a burden off of our clients as possible. They're going through likely the worst possible thing that they could have ever imagined, the worst experience in their life. We want them to focus on their family members, on their medical recovery, and let us worry about everything else. Let us worry about dealing with insurance people, paperwork, liaising between private insurance and your auto insurance and your third party group insurance through work. So that's our objective in each and every case, is to give the resources that's required, make the journey as easy as possible for the client. We wouldn't be able to do that if we diluted our practice and had a high volume. And I understand why firms do that. The smaller cases, the quick turnovers help with cash flow. And we probably, make less money than a lot of firms because we don't do the high volume, quick turnover. But, I'd rather our approach, we're highly specialized, we're deeply prepared, and relentlessly focused on achieving our goal for our client.
You have a reputation as a very tech-forward firm. I know AI is on the minds of everyone, and it continues to come up in legal conversations. Is that commitment, do you feel, to technology more important now than ever in the world of AI? And can you share how the firm is embracing the newest tools and how they're making a difference?
Yeah, and I credit John McLeish for this. When we started the firm in '99, we wanted to be right at the cutting edge, and that started with creating a document management system called Prime Effect that John was actively involved in creating. And since then, we've always had an eye on what is the next best technology that's going to help improve our efficiency and better service our clients. We struck an AI committee probably 2 years ago, 18, 20 months ago. We kicked the tires on a lot of different products, and the AI wasn't there just yet. But boy, did it get there in a hurry, Brody. I mean, we had transitioned to a program called FileVine, which is our document management. So it basically does everything. All of our documents are in there. Our calendaring is in there. When we communicate internally on a file, they're called notes. So we communicate through FileVine notes. Emails are all stored in there. Task assignments are all in there. So everything's within the FileVine environment. We looked at a few different AI offerings, but we went with FileVine and it's called Lois. So Lois has the benefit of knowing exactly what's going on in that case. It can look at to-dos, it can look at the notes, it can look at emails, it can review documents, including transcripts for examination for discovery. And we are about 6, maybe 7, 8 months into it now. It continues to improve, and it would blow you away at how effective it is. I mean, it basically performs the majority of the tasks of what a senior law clerk or a junior lawyer does. It knows every fact in the case. You can ask it anything, and if the fact is in there, it'll find it. It leads you to the documents. It can review and critique medical reports, comparing it to file content. I can read a defense memo, and it'll say that my client had said this or that at discovery. Or I can just put that right into Lois, and Lois will say, well, no, that's not what was said. Here's the line reference. So, I mean, it's a huge productivity tool. It's been really, for somebody like me who, like, I'm not day to day in the minutia on the file. I used to have to rely heavily on the junior lawyer or the clerk that was really familiar with the file to get the answers that I needed. I can do it on my own now with Lois, and it frees up the clerk and junior lawyers to do more complex tasks.
Yeah, it's incredible the efficiencies you're able to find. That's amazing. You've spoken to the importance of preserving a robust tort system and resisting a shift toward complex first party regulatory regimes where the injured people may never get their day in court. You've spoken about this. And as policymakers consider accident benefits reforms and procedural changes through 2026 and beyond, what concrete changes would you like to see to better protect seriously injured plaintiffs? And how is your firm engaging with those reforms?
Yeah, so I mean, I think we have a great system in Ontario because we've got this hybrid system. There's potentially two streams of compensation that are open to people that are accident victims, and so if you're the at fault party and you have a catastrophic injury under our system, you still get access to income replacement currently, med rehab, which is great. I mean, for somebody who suffers a catastrophic injury, even if it was their fault, they were texting and driving or they weren't paying attention for whatever reason, their lives are going to be significantly compromised by their catastrophic injury, but at least there's support there. But that's not a great system in general because it's heavily burdensome. The notional $1 million that you have for your med rehab and attendant care might be illusory, right? Because it's not, they don't give you the money. The insurer doesn't write you a check. It's based on, is it reasonable and is it necessary? And clients can get ground down through this assessment process, the approval process. And there's very little in the system to punish bad behavior by insurers. There's bad faith is really not a thing anymore under the Ontario system. So it's great if somebody has their tort rights, right? A lawsuit has a beginning, a middle, and an end. Money doesn't obviously undo the harm that was caused by an accident. Somebody that has a catastrophic injury and they get this huge lump sum of money would give every penny of it back in order to get their health back. But at least the tort system allows them that end of the day, right? It might be 3 years, it might be 4 years, but at the end of the case, they are entitled to receive fair and reasonable compensation for everything that they lost. And they don't have to deal with an insurance company for the next 10, 20, 30 years. They're entitled to this compensation, whether it's for loss of income or their future care needs. And then it's on them to administer and manage that money as best as they see fit. So there are currently proposed changes to the no-fault system. At least at this point, there doesn't seem to be any ongoing threat to people's rights to have their case tried and have an end of the day and a tort result. The changes that are being proposed will make most benefits in Ontario optional, which is, an insurance company and the insurance industry will say, well, we're giving people choice, Brody. And the reality is the majority of people don't realize what options are available. The uptake for optional benefits is about 2% right now, and we don't expect that to change. And I think a lot of people will be in for, an unpleasant surprise when, they've suffered a serious injury and they no longer have access to income replacement benefits or caregiver benefits because they didn't purchase that option. Now, med rehab will be preserved, but everything else becomes optional. Even things like expenses of visitors. If your loved one is at Sunnybrook for 4 weeks, well, you're paying $40 a day for parking. You're having to buy meals in the hospital. You're paying for an Uber or a taxi, or you're driving. Those are all expenses that are currently covered. And, for an awful lot of people, those are expenses that are not going to be manageable. And they come at the worst possible time because their loved one is now not working. So I think we've advocated to try to preserve the current system as best we can, mostly through the Trial Lawyers Association and the Political Action Lobby. It largely falls on deaf ears, we find, but we're hoping to preserve the system as best we can.
After more than 2 decades focused on brain injuries, spinal cord injuries, and other catastrophic harms, you've witnessed enormous changes in medicine, technology, and the practice of law, from virtual hearings to more sophisticated rehabilitation teams. On a personal level, which recent developments do you feel have most transformed your client's recovery journey and your own approach to advocacy? And where do you see the next big shift coming from top personal injury boutiques like yours?
Yeah, I'd say, I mean, I'm at 30 years now of doing this. You can imagine the amount of change I've seen, from snail mail to fax, and, everything was suddenly being sent by fax. And then, email became a thing. It was like, wow. In the old days, Brody, I'd get a letter sent to me. It would take a week to get to me. Then I would have to respond to it, and it might take a week before it got out of the office, then a week to get back. So to the defense counsel, and, now I'm getting follow up, like people are emailing me at 9 in the morning, and then they're bumping it back up at 4 in the afternoon. So the pace at which the replies are required it has really significantly changed. That's for the bad, right? I mean, client service is what we're all in the service industry. We're hired by a client to do a great job for them, and delay does not work in our client's favor ever. So the more efficiently we can move the case through the steps in the process, and there are inherent delays in the process. I mean, you have to wait a year and a half oftentimes for my client's medical recovery to plateau. But objectively, we don't want to ever have a delay that's not an institutional delay. Sometimes you're waiting for court dates, or you have to delay your examination for discovery. But we want to move everything as efficiently as possible, and because there are enough delays in the system. So, things that have helped our clients on the tech side Zoom has been huge. I mean, as much as, there's a loss in the collegiality. You're not at the court reporting service seeing 10 or 15, members of the bar, whether on your side or the other side. You're not at the courthouse for the pretrial hearing. Everything's over Zoom. So I think there's a detriment, particularly for younger lawyers, because they lose out on that kind of the networking aspect, and that sort of quiet learning, the subtle learning that happens just through observation and being part of a bigger group. But it's been much better for the clients, right? They do their examination for discovery while they're sitting in their living room, as opposed to the anxiety producing, I've got to get dressed, I've got to get downtown Toronto for 10 a.m. I've got to sit in a boardroom with a court reporter and defense lawyers, and it was just a horribly stressful environment for them. And I think it is still stressful, of course. It's just much less stressful. Same for pretrials. I mean, they're not sitting in a courthouse. They're sitting in their kitchen or their living room. And, just there's obviously conveniences for the lawyers as well, because, we used to, if I had a pretrial in Sudbury, well, that was a day out of my life. I, fly up the night before, get up really early and drive up day of, and you have your 1 hour long pretrial, and then you're back in the car for another 4.5 hours. And now, it's an hour, you log in on Zoom, and it's over. So I think Zoom, has been really important. In terms of, on the medical side, we're seeing breakthroughs and advances in treatments and technology. I think there's some really exciting work being done in the stem cell area. I've heard some really great lectures. Robotics is huge. Who knows about Elon Musk's chip implant, whether that's going to, I mean, all of these things are making our client experience in dealing with their injuries and their permanent disability that much easier. And I think ultimately, Brody, I'll be out of business because I think full self-driving, which we're about 80% of the cases we handle are auto cases. And we've already seen like a great reduction in the severity of injury based on safety improvements to date. from, the airbag technology is greatly improved, lane keeping, all sorts of aspects of the, you see it in your car. Everybody that drives is, constantly being reminded that, oh, you're drifting out of your lane, or there's somebody in your blind spot. And I don't know if you've driven a Tesla at all, or and been playing with the full self driving, but it's good and it's getting better. And I think ultimately, right now it's, my wife says, well, it's scary to let a car drive, like the computer's driving the car. And I say, well, what's scary is having a 16-year-old, who's texting and driving, or somebody who worked a double shift and is exhausted. Or, my dad's still driving and he's 86 and probably shouldn't be. So, I think there'll be advancements in auto technology that will really significantly reduce the number of injuries. And if it puts me out of business, well, that's great, because it means people aren't suffering catastrophic injuries.
Well, you certainly have a front row seat to all of these changes. And it was great to hear your perspective on all of this today. Dale, thank you so much for being in conversation with us. And a huge congratulations to everybody at McLeish Orlando, being named one of Canadian Lawyers' top personal injury boutiques for 2026. Thank you so much.
Thank you for having me on today, brother.
Your dedication, advocacy, excellence, and supporting clients through some of life's most challenging moments continues to set your firm apart. Again, this is Brody Lawson, and thank you for watching Canadian Lawyer TV.